a third category of international armed conflict, which is subject to its own legal regime, is wars of national liberation. Article 1.4 of Additional Protocol 1 defines wars of national liberation as being those wars in which people are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. There are 5 observations to be made concerning the definitions of wars of national liberation. First observation. The Geneva Conventions originally treated wars of national liberation as non-international armed conflicts. However, this approach was increasingly questioned during the 60s and 70s by new states, which had emerged from the process of decolonization. These states argued that wars fought against colonial powers should be treated as international armed conflict and that liberation movements should benefit from the protection of the full body of IHL rules and in particular from POW status. The growing weight of opinion behind this view was reflected in numerous resolutions adopted by the United Nations General Assembly, calling upon states to apply the laws of international armed conflict to such wars. Eventually, this new consensus was formalized in 1977 with the adoption of Article 1.4 of Additional Protocol 1, which recognized that the laws of international armed conflicts govern certain armed conflicts that are fought between states and national liberation movements. Second observation. Pursuant to Article 1.4 of Additional Protocol 1, national liberation movements would qualify for protection providing that they were fighting in the exercise of their right of self-determination against colonial domination, alien occupation, and racist regimes. The meaning of these terms is not exactly clear. Usually, colonial domination refers to traditional ideas of colonialism. Alien occupation corresponds to colonies of settlement, and racist regimes are intimately linked to the South African regime of apartheid. The drafting history of Article 1.4 makes it clear that its scope of application is limited to these 3 situations. That said, many armed groups have claimed that these provisions should also encompass all conflicts that are fought for the purposes of exercising the right of self-determination. Some scholars consider that, for that to happen, armed groups must be broadly recognized internationally as having acquired the kind of status envisaged in Article 1.4 of Additional Protocol 1. Third observation. It is not clear whether a liberation movement must meet other criteria, such as being recognized by the General Assembly of the United Nations or organized in such a manner that they can apply the detailed rules governing international armed conflicts. While reasons of effectivity militate in favor of requiring from these movements a certain level of organization, the text of Article 1.4 does not impose any further conditions. Fourth observation. Additional Protocol 1 does not determine the level of intensity of the hostilities that must be satisfied in order for an outbreak of violence to be qualified as a war of national liberation. This question has also generated controversies among scholars. For some, a high level of intensity is required. For others, no such conditions is found in the text of Article 1.4. They also argue that wars of national liberation must be assimilated to international armed conflicts, therefore are triggered by a minimal level of violence. Fifth observation. It is important to recall that pursuant to Article 96.3 of Additional Protocol 1, an additional condition must be met before Article 1.4 of this protocol apply. the authority representing the liberation movement must address a declaration to the Swiss Federal Council, depository of the additional protocols, by which it undertakes to apply the Geneva Conventions and Additional Protocol 1. To date, only one such a declaration has been successfully made, the declaration made in 2015 by the Polisario Front from Western Sahara.